Good morning, everyone. We're going to get started. Thank you very much for taking the time to join us on this beautiful spring day. I think you all know me by now, but if not, I'm Lauriane. I'm the head of events at the French Chamber. It's my pleasure to welcome you to this webinar organized today with Newland Chase, who's a member with CIBT. CIBT joined the Chamber just before COVID, so we're very happy to be able to do this webinar with them today. As usual, we'll have time to take your questions at the end of the webinar, so do please send them through the Q&A button, which you will find at the bottom of your screen. That's it from me. A big thank you to CIBT and Newland Chase and to you for joining us, and I'll just hand over to Joe to tell you a bit more about the webinar today.
Hi everyone, thank you all for attending today. I am Joe, I'm one of the account managers at CIBT, and I've been working with the French Chamber alongside Newland Chase to arrange this webinar for you guys. And so just so you know, Newland Chase sits under the CIBT umbrella and is actually the immigration arm of the business. And as you all know, Brexit is finally passed and the UK is officially out of the EU. So there's been some changes which has impacted upon business travel for both UK nationals going outbound into the EU and EU nationals coming inbound into the UK. So this is where my two colleagues joining us, Newland Chase today, Ben and Tony, will be talking about this. So I will hand over to those guys now.
Okay, lovely, thanks, Joe. I'm just going to get the presentation up. Good morning, everybody. And firstly, thank you to the French Chamber of Great Britain for giving us the opportunity to present today. I'm Tony Butterworth. I'm one of the managing directors. I head up the UK practice at Newland Chase, and I'm joined with my colleague Ben Sukia, who sits within the Global Immigration Advisory Team at Newland Chase. As Joe said, we are going to be presenting on essentially the impacts of Brexit and what that means from an immigration and mobility point of view. I'm going to start with presenting the UK position, so EU nationals travelling into the UK, and I'm going to cover those agenda points listed on the left. And then I'm going to hand over to my colleague Ben, who's going to do the reverse. So he's essentially going to present on UK nationals travelling to the EU and some of the impacts of our departure from the EU in terms of immigration. And then at the end, we're going to have Q&A. If there are any questions posed throughout, please do use the Q&A function. We'll pick those up. And there are our contact details at the end of the presentation. So if there's anything you'd like to take offline, if you'd like to pick anything up with either Ben or I separately, then obviously please feel free to do so. So with the agenda out of the way, I'm going to move on to EU nationals and the UK. So just to sort of frame today's webinar, and just to put it into a little bit of context, in January 2020, we signed the Withdrawal Agreement as it pertained to citizens' rights, and that essentially sparked off a transitional period which ran through to the end of last year. That came to an end on the 31st of December, which effectively meant that free movement rights under the transitional arrangement also came to an end. We enjoyed free movement throughout the EU and EU citizens coming into the UK for over 40 years. So it was really a stark change to the previous regulations which were in place. What that essentially means is that all EU nationals who now travel to the UK will require a form of work permit if they're coming here to work, and I'm going to look at that in a little more detail. Before I move on to looking at some of the work categories and also discussing some of the business visitor requirements and things that you need to be thinking about from both the work and business travel perspective, I just want to remind you that the EU settlement scheme, which is the scheme that the UK government implemented to allow EU citizens who were in the UK before the end of last year to continue living, allows you to continue working in the UK, does come to an end. There is a deadline to make that application, which is the 30th of June this year. So if any of you on the webinar today are responsible for managing your EU nationals within the UK, so your EU national employees, I do think it's prudent to probably raise awareness, continue with your comms if you've been doing so, just to remind your EU population that they do need to apply under the EU settlement scheme, with the deadline being the 30th of June. That's really important. If they haven't applied by the 30th of June, then they would be considered to be in the UK unlawfully, and that's not a position you would want anybody to find themselves in. One other thing to mention before I crack on with looking at some of the work routes, when I talk about third country nationals throughout the presentation, I will be referring or including EU nationals, because they are now considered as third country nationals, but Irish nationals are exempt. A question that I always get asked at the end, because I forget to mention it at the beginning, is what about Irish nationals? And they do not need to apply for work visas for the UK, okay? Nor do they need to apply under the EU settlement scheme. So they're sort of ring-fenced off from the post-Brexit immigration rules. So I've mentioned the transitional period, and also those who are arriving from the 1st of January 2021 onwards, if they're coming here to work, will need a work permit. So I'm just going to quickly run through the work permit regulations, which we've now implemented since the 1st of January. So in the UK, we essentially have two work-based routes. We have the skilled worker, which is essentially designed to allow permanent hires into the UK. And we have the intra-company transfer, which is designed more for temporary assignments, so things like secondments, short-term project-based moves. Both of these routes effectively replace the old Tier 2 scheme. So some of you on the webinar today may be familiar already with UK immigration. And if you are, then you'll be familiar with the old Tier 2 route. It was, again, split into two parts. There was Tier 2 general and Tier 2 intra-company transfer. The skilled worker has effectively replaced the Tier 2 general scheme. I'm just going to sort of contrast some of the changes against the old scheme. So again, for those of you who may be familiar with the Tier 2 general, you would no doubt be aware that there was a requirement to advertise for 28 days before you could offer the role to a foreign national. That's been abolished under the new skilled worker route. So there'll be no more advertising, which means that delay of 28 days and all the administrative process that went around that, the sifting of CVs, the interviewing, the business case, that's no longer a requirement. So that's actually quite good news. Also, the annual limits, we were restricted to, I think it was 20,700 work permits. That's been suspended for the time being. That may change in the future, but for now, there are no limits on the annual numbers that we of work permits that we issue under the skilled worker. The Home Office have also reduced both the minimum salary level and also the minimum skill level, which means that those roles that previously didn't qualify under the old Tier 2 general route, which was set at sort of graduate entry level, will potentially now qualify, which is good news. There is still an English language requirement, and one thing to note here is that EU nationals do not automatically qualify for meet the English language requirement by virtue of their passport, as some countries do. What that would mean is that if you did want to sponsor an EU national under the skilled worker route, they would either have to have a degree which was taught in English, or sit and pass a recognised English language qualification. Right? So do bear that in mind. And finally, the skilled worker route is a route that does lead to permanent residency. So if you are looking to hire somebody for the long term, then you would want to be looking at the skilled worker route. And, you know, in general, excuse me, the changes to the scheme are just simply more attractive. The Home Office have certainly made the qualifying criteria easier. Reducing the skill level has been seen as, you know, quite an attractive move. So that's skilled worker in a nutshell. With regards to the intercompany transfer, there haven't been too many changes, although there is a consultation going on at the moment just to sort of review that and see if it's sort of still set at the right level. So there's no advertising for the intercompany transfer, but there never was. The minimum salary remains at 41,500, which is the minimum that you have to pay an intra-company transferee. The individual would typically need to have 12 months of experience with the organisation overseas. And again, the skill level continues to be set at the previous level, which is RQF level 6, or broadly the equivalent to a degree level qualification. So what you'll find are that you won't be able to transfer some of the more junior or less skilled roles. If you're looking to fill those, then you're going to need to be looking at the skilled worker routes. Also, there's a limit of 5 years in any 6 years on a rolling basis. So it does not lead to permanent residency, but there is no English language requirement. So the applicant would be exempt from English language, which means they wouldn't need to do that test potentially. And as I've already mentioned, it doesn't lead to permanent residency. So I suppose the question you might ask is, well, why would we use the intra-company transfer over the skilled worker? I suppose the only real benefit is that there isn't this English language requirement. There's this speed of deployment. You would potentially be able to move somebody on an intra-company transfer visa a little quicker. And it is short-term. It is designed for sort of short-term projects secondment, so you may want to utilise it for that. So those are the two main work routes in brief. If you have any questions, do feel free to fire those away in the Q&A. And finally, I just want to mention frontier workers. So frontier workers do actually fall outside the immigration rules as such. They only relate to EU, EEA and Swiss citizens. So an American national, for example, wouldn't benefit from the frontier worker regulations. How the frontier worker scheme works is that it's designed to allow cross-border commuters to continue to work in the UK. What I mean by that is somebody who lives overseas and has travelled across borders into the UK and has worked in the UK, but essentially live elsewhere. Okay, so you may have employees who have done that. I appreciate that last year they may have been affected by COVID. That may not preclude them from applying. They may still qualify if they can show that they were travelling in 2019 to the UK and working. I've mentioned that the work needs to be genuine and effective. What does that mean? It means it needs to be more than a simple business visit, or somebody had simply come here maybe to attend a seminar or a conference. So it does need to be substantive work that they were undertaking. Must have been active before the 1st of January this year, hence the point about working last year or maybe earlier. And again, there is a deadline to apply, which is the 30th of June. The frontier worker visa is valid for 5 years, can be renewed, but doesn't lead to permanent residency. So why would you apply for a frontier worker over either an ICT or a skilled worker? I would say predominantly it would be down to cost. The skilled worker and the intra-company transfer are quite costly, whereas the frontier worker is free of charge. I'll come on to costs as I go through the presentation today, but just something for you to consider if you are managing that EU employee population and you do have people who have been travelling to the UK to work, you might want to encourage them to apply for the frontier worker visa. Okay, so we've looked on the available visa routes to allow people to work in the UK, but what do you need to do as an organisation? So I'm making an assumption here that there could be potentially two groups of you on the webinar today. There'll be those of you who hold a sponsor licence, and there may be a group of you who haven't applied for a sponsor licence. I mentioned a sponsor licence because it's a prerequisite for the organisation itself to hold a licence which is issued by the UK immigration authorities to allow you to sponsor, so effectively employ foreign nationals in the UK. Okay, so I've mentioned it's a prerequisite. The organisation itself has to apply. I'm going to look at what an organisation who doesn't hold a sponsor licence needs to do firstly, and then I'll come on to those of you who do have a sponsor licence and just cover some of the points that you may need to start to think about. So gather significant company documentation. The Home Office will require you to submit an application which is accompanied by a set of company documentation, as I've pointed out. Things like accounts, lease agreements for the office, tax documents, and so on and so forth. So you need to start to think about gathering those documents. Hence, you need to be a trading entity in the UK. You'll need to appoint key personnel. So again, you'll need to have employees who are UK based. You can't simply have a company which is set up, not trading and not having any UK personnel. That's really important. Also understanding your compliance obligations. When you apply for a sponsor license, the Home Office will expect you to be able to manage your immigration program effectively, to ensure that you can complete right to work checks in the correct way, to ensure that you can track your migrant workers, to know where they are. So there's a list of obligations that you have. You'll need to understand what they are, because it essentially underpins the immigration program that you'll be running. And therefore you'll need to build robust processes to manage those obligations. A lot of them are simply HR good practice, but some of them are more tailored to immigration. So things like right to work and tracking of sponsored workers, and some reporting obligations that are quite specific. I've also made reference to submitting a perfect application. I know it sounds fairly obvious, but you'll be surprised at how unforgiving the Home Office are, or maybe you won't be surprised. But the authorities in the UK, they often won't, be flexible. So if you were to submit an application which, for example, had a document that wasn't certified in the right format, or maybe didn't meet the requirements, typically the Home Office will simply reject the application rather than request a new document. Why is that a problem? Well, as I've mentioned at the end, the lead time for an approval is about 6 to 8 weeks. If you don't submit a really spot-on application and it gets rejected at the end of that period, you're basically back at square one. You've lost a couple of months. You may have a key hire who needs to, come to the UK, and it's simply going to delay the overall onboarding process or your ability to transfer somebody. So do make sure that you get your documentation in good order. Newland Chase can assist with all sponsor license applications. So if you do need assistance, do feel free to contact us. And just looking at those of you who do have a sponsor license, particularly those of you who may have a license but haven't particularly used it frequently because you haven't really had the need, but may need to start to use it more often now because you'll need to think about your EU nationals who you may want to either hire from the EU or transfer from the EU. So I've mentioned ensure that your license is fit for purpose. Just a few pointers here, things to be thinking about. So I've mentioned key personnel already. You do need to ensure that the same key personnel who were on your license previously remain in place. What do I mean by that? So we've had clients who have come to us to do some work for them, and when we've sort of done some due diligence around their license, we've noticed that the authorising officer, for example, has actually left the organisation. That would mean that you'd be non-compliant. You must maintain your key personnel at all times. So do check that whoever is listed on your license remains an employee of the organisation. That's really important. Also look at your overseas entities and ensure that they're linked to the UK license. If you're looking to transfer somebody from an overseas office, say Paris or Madrid or Frankfurt into the UK, you do need to ensure that that office has been linked to the UK sponsor license. Likewise with UK offices, to ensure that they're linked. You can't simply transfer somebody or hire somebody into an office which hasn't been linked to the license if you have multiple offices around the UK. So just, sort of do a bit of a spring clean in that regard, check that everything's up to date. Also with your certificates of sponsorship, that's the document that you would issue to somebody to start the visa process. That's effectively the work permit document. Do make sure that you have a sufficient allocation, particularly if you're expected to see a spike in demand for sponsoring foreign nationals into the UK. You'll have an annual allocation. Okay, just make sure that you have sufficient to be able to cope with those. You can request more at any time. But, as I've mentioned at the end, don't get caught on the back foot. Also make sure that you have both the skilled worker and the intercompany transfer tiers on the license if you are looking to utilise both of those categories of visa. We found that clients who have one or the other have started to add those just so that the license is essentially whole and you have all the opportunities in this regard. Excuse me. And also keep an eye on the license renewal date. Your sponsor license is valid for 4 years. We have had clients who haven't used it frequently and have let it lapse. What happens when it lapses is effectively you're back at square one and you need to apply over again. A bigger issue potentially is if you let your license lapse and you have sponsored workers working for you, they would actually lose their visa potentially. So that's a big problem. And just finally, ensure that your in-house teams are au fait with the new immigration rules. You know, it has changed. They've changed quite drastically. I'm thinking, you know, teams like global mobility teams, HR and recruitment teams. So just to make sure that they are familiar with the new immigration landscape, the rules, the processes and so on and so forth. I've mentioned processing times. The Home Office, they do take a long time to process anything, typically 10 to 18 weeks. So, you know, some of the things that I've mentioned, they do need approval before you can, you know, transfer somebody or move somebody into a license, into an office which isn't on the license. So, you know, I would suggest you act sooner rather than later if you need to update anything on your license. So that's the work-based routes, both the visas and the sponsor licenses. I'm now just going to touch briefly on business visitors. So again, the end of free movement, as I've mentioned in my first point, represents a marked shift in working culture of European operations. You know, under free movement, you never really needed to think very much about business travel to the UK. Essentially, an EU national could hop on a plane or a ferry or a train, be in the UK and conduct their business, whether it was work or a simple business meeting, without you really needing to think very much more about it. That's now changed, and it's changed quite significantly. The first point I should mention, though, is that EU nationals do not require a visa per se to come to the UK on a business trip. You know, they do need a visa if they're coming here to work, but for something like a meeting, to attend a conference or a seminar, they do not need a visa as such. But of course, the fact that they now do fall under the immigration rules, because the UK Home Office have not made distinction between EU nationals and foreign nationals, there are, I suppose, now more concerns around compliance and immigration risk. There'll certainly be greater scrutiny of your EU nationals travelling to the UK on business trips. And in fact, only a few weeks ago, I had a French national who had travelled to the UK, hadn't realised that she needed a work permit now to work in the UK, was stopped at immigration and was refused entry because she was coming here to work, didn't have a work visa in place, and got turned around and sent back home. So, you know, I still don't think that the fact that the rules have changed has necessarily cascaded across all businesses, you know, who are sending people from the EU to the UK. So what are the risks involved? Well, of course, as I've just highlighted, there's a risk to the individual. They can be refused entry, can be banned in certain cases. That's quite drastic, but it can happen. There's also the direct impact on your sponsor status. If somebody were to come in as a business visitor, but was to be working and was found to be working, you can lose your sponsor license. You can be fined up to £20,000, which is not an insignificant amount. And then, of course, there's the reputational damage. So you don't want to be caught having people working for you in the UK without the correct permission to do so. So just a little bit more about business visitors. So I've mentioned business visitors can travel to the UK for reasonable periods of time. Unlike the EU, we don't have a limit to how long or how frequently somebody can come here on a business visit. We don't have a 90 days and 180 days limit, as I understand is applied across the EU. Essentially, when somebody comes here as a business visitor, they're given a stay of 6 months, but I would suggest that a stay of more than 4 weeks would start to raise some red flags. So if you're sending people on a business visit, I would be looking at the duration that they're coming here for. You need to be thinking about the permissible activities, so the reasons why they're coming, and also the frequency of travel. Just to sort of bring those 3 points together, if somebody was coming here for, say, a month at a time, that would be perfectly fine. If they were conducting permissible activities, I think that would also be fine. But if they were doing that very frequently, say coming here for 3 or 4 weeks, leaving for a week, coming back for 3 or 4 weeks, and continuing that pattern, that would start to raise some red flags. So you do need to think of this from different strands. Of course, they can keep in touch with their overseas employer whilst in the UK. Also check emails to make sure they're up to date with their overseas work. They can receive reasonable travel and living expenses. but they cannot be paid from a UK source, must remain on their overseas payroll. And of course, they absolutely can't work in the UK unless the activity they're undertaking is permitted. Which brings us on to some of the permissible activities. The ones I've listed here, I won't go through them in detail, but these are the obvious ones: attending meetings, conferences, seminars, giving talks, negotiating trade deals and signing contracts, attending trade fairs, site visits and inspections and things of that nature. So I would suggest that you familiarise yourself with what are permissible activities, just to ensure that if you are managing that population of business traveller, that you are aware of what they can do when they're in the UK as a business visitor. Likewise with intra-corporate activities, this is where it starts to get slightly more precarious, if you like, because some of this sort of crosses over into work, which may be permissible. So things like troubleshooting, if you were sending an engineer to install machinery, for example, that may be perfectly fine. If you were sending one of your software engineers to debug or troubleshoot on a software or IT system that you've provided to a UK customer, that may also be fine. But you do need to be a little cautious around those sort of work-based activities. Again, I've mentioned duration. I think personally, anything more than a month starts to attract suspicion, and we always advise our clients to try to confine the duration to a month or less. Ensure that it's linked to a specific project, as I've mentioned above. You can visit customers, but it does need to be linked to either the supply of goods or troubleshooting, things like that. And again, a visitor cannot work, that's simply prohibited. And typically should be based at your UK offices, with the exception of some of those who need to visit a client site to install or debug systems. So again, if you familiarise yourself with some of those key points, and what a business visitor simply cannot do. So take employment, I think that's fairly obvious. Nor can they establish or run a business, either self-employed or on behalf of an overseas employer. There are visa programs in place to allow people to establish businesses in the UK. Also undertake work placements or internships. This is a question that keeps cropping up. I think there's this misconception that business visitors can come to the UK to undertake a work placement or internship because it's not deemed to be permanent employment. That's not the case. Again, there are visa programs in place to allow internships within the UK, but a business visitor simply does not facilitate an internship. So do be careful about that. Again, providing temporary cover or short-term cover for a UK role. If you're covering a UK role, you're going to be working, as we've already established, even for a short-term period of a month. If it's work, then a work permit is required. So don't fall foul of thinking that just because it's a short-term period that a work permit isn't required. It would be. I've mentioned selling goods directly to the public. That's prohibited. And taking any form of employment. So, just be conscious of the things that you can and can't do, or rather your employees can and can't do. So just some practical tips. So the passport validity, just to ensure that it is valid for ongoing travel. We don't require it to be valid for 6 months or 10 years, like I know some countries do. It just does need to be valid for the departure from the UK. EU national ID cards, you've been able to travel on those up until now. They'll continue to be valid until the end of September, after which only a passport will be valid for travel to the UK, unless you have status under the settlement scheme. And I think you can use your ID card until 2025. I would strongly recommend providing justification for travel letters, what we call a back pocket letter. It sets out why somebody's coming here, so the purpose of the visit, the duration, who's covering the expenses. It just does help facilitate travel if somebody starts to get grilled by immigration. They provide the letter, it should have contact details, and it often just irons out any creases for immigration. Evidence of financial means that can be stated on the letter, and also an itinerary. It's always prudent to be able to show where somebody's staying, so hotel bookings, and also an outbound travel ticket is also very helpful to show when somebody intends to leave. So just some practical tips. And just finally, the impacts and things to be thinking about. So what are the impacts? So ease of travel is going to change. I hope I've highlighted that. Somebody coming here to work will no longer be able to do so freely as they did under free movement. Costs, I alluded to costs earlier. Just to give you an example, a 5-year skilled worker visa with government fees is going to cost you somewhere in the region of about £8,000 to £9,000. It's not inexpensive, it's very expensive. Timelines are longer. When sending somebody, of course they are, because for free movement, you could have simply sent somebody, they could have started working the next day. In general timelines, you probably want to be thinking in terms of 6 to 8 weeks for the end-to-end process. What does that mean in terms of start dates? Well, they're impacted because they can often get pushed back. The hiring process is going to be longer. I've mentioned the scrutiny around business travel. And also the mindset shift, again, going back to my point earlier with, some individuals and organisations still not really coming to grips with the impact of Brexit. So, I think that's a question of, education and ensuring that, your stakeholders are aware of the impact. Considerations, assess the need for a sponsor licence. If you do need one, apply sooner rather than later. Again, evaluate your in-house resources and capacity. And just look at your current sponsor license just to ensure that you are aware of your sponsor duties. And then finally, what to do now. Apply for a sponsor license or have a refresher of your existing one. Educate internal stakeholders, global mobility, HR, travel and recruitment teams. And just ensure that your processes are robust, fit for purpose, particularly if there's going to be a spike in demand for a sponsorship. And just a final parting point from me, remember that all work, no matter how short, does require a work permit. And with that, I'm going to pause and come up for air and pass you over to my colleague Ben.
Great, thanks so much, Tony. Really appreciate it. And thanks again to the French Chamber of Commerce for giving us this opportunity to talk about post-Brexit immigration. So what I'm going to be doing is covering what UK nationals going into the EU need to do. And I'm going to start with dipping back into the withdrawal agreement that Tony touched on a little earlier. So just to go back into that, the withdrawal agreement aimed to protect work and residence rights of all EU and UK nationals who made use of the freedom of movement before the end of the transition period. So protected by the withdrawal agreement are primarily UK national residents and cross-border commuters in the EU before the end of the transition period on a local employment contract or registered as self-employed. So to guarantee this protection, EU countries have opened up country-specific processes for these UK nationals specifically, so that they can obtain a new residence document that certifies that they are actually protected by the withdrawal agreement. These schemes are now opened in all EU countries, and they're going to remain open in France until around the end of June 2021. So that's actually, it's not actually that far away. So it's something to be mindful of in case you do have employees or you yourself would require that residence document. And it's quite a straightforward process. But despite that, there is still uncertainty around UK nationals who started to reside and work in the EU just before the end of the transition period on an assignment. So they would be obviously on UK employment contracts. We do have EU countries who are allowing UK nationals on assignment to just carry on working, while others are actually also asking for a separate work permit. So again, it goes back to that point. It really depends on which country that individual is going to. But not protected by the withdrawal agreement are the new UK nationals who are arriving to the EU for business, work or residence after the 1st of January of this year. If you can move on to the next slide, please, Tony. Great. So what's new? What is the new immigration landscape for UK nationals in the EU? Well, from January 2021, UK nationals are considered third country nationals. Tony mentioned that again. So for long stays, they are going to be subject to the rules of the specific EU country where work is intended and require work and residence permit in that country. So UK nationals, as third country nationals, they'll be treated just the same as for example, US or Australian nationals. Now, for entry and short stay, they are subject to the entry requirements governing the crossing the Schengen area, which are laid down in Schengen regulations, and those are set out in front of you on this slide here. So for short-term activities of up to 90 days, they will again be subject to the specific national law of the country where that activity is going to be carried out. But having said that, it's really important to mention that not many EU countries have regulated what is possible to do or not possible to do on business. It remains a grey area. It's one of the most common questions that I'm asked today, in fact. So this is the case for France, where business visitor activities, they are mentioned in immigration law. However, they're not detailed as specifically as they are compared to, let's say, UK immigration law. So it's precisely due to the lack of regulation of business activities by so many EU countries, France being one of them, that we welcome the provision on business activities included in this new exciting EU-UK Trade and Cooperation Agreement, which we call the TCA for short. So the TCA provides more of a definition for business visitors for establishment purposes and short-term business visitors in general. And it also gives a list of common permitted activities. So in the next slide, you'll see the definition of business visitors for establishment purposes. Thank you very much, Tony. So I'm just going to read out the slide because this is so very important to how we will define what someone who is a business visitor, who can be considered a business visitor. So a natural person working in a senior position within a legal person of a party who, one, are responsible for setting up an enterprise of such legal person in the territory of the other party, two, do not offer or provide services or engage in any other economic activity, and three, do not receive remuneration from a source located within the other party. The permitted length of stay is 90 days within any 6-month period. Again, there's a caveat there for Cyprus, who have made a non-conformity measure and is supposed to allow business for establishment purposes as defined here for 90 days in a 12-month period. So that's really important to remember in terms of the definition of what a business visitor is under the TCA. But if we move on to the next slide, we'll then talk about that in a bit more detail in terms of what short-term business visitors are. So again, short-term business visitors do not or cannot sell goods or supply services to the public. They can't receive remuneration from within the country where they are staying temporarily, and they can't supply services in the framework of a contract with a consumer in an EU country where not established, unless that provision of services is a permitted activity listed under the TCA. So in the next slide, we're going to see what the list of permitted activities actually are. If we move on to that, Tony. Now, I won't read this out because it's quite a long list, but let me just take a moment to take a look there to see what is actually possible. And that, as I said, is the list of permissible activities as per Annex Servin 3 under the TCA, which allows business visitors in general, including for establishment purposes and intra-company assignees. So while we can't deny that the TCA agreement provides certainty to UK nationals on business travel to EU countries, it's really important to note, however, that some EU countries have opted out of one or more allowed activities, or they have made specific reservations to its application. So, for example, under the TCA, for France specifically, there are certain permitted exemptions. For example, activities such as sports or cultural artists or attending scientific events are permitted as an exemption under French immigration law. So it's really important to, yes, look at the TCA, but more importantly is actually take a look at that and consider what it says under national law as well in each country. And obviously today we're focusing on France. So just to move on to the next slide in terms of the entry requirements, if you are able to come in under the Schengen rules. Now, not only do we need to know whether an activity is or not permitted in the EU country We also need to ensure that UK nationals comply with entry requirements as per Schengen regulations. So this goes a little bit back into what Tony was saying as to what you're allowed to do as a business visitor, and even if you can come in as a business visitor, what you should be mindful of. So let's take a look at this. It's really important on this side, coming to the Schengen area, unlike what Tony mentioned, that passports have been issued within the past 10 years. Passports need to be valid for at least 3 months beyond planned date of departure, although, as it's pointed out on the slide, I do always recommend 6 months as a precaution. You need to be able to justify the purpose of travel. You need to be able to prove financial means. You need to have a specific itinerary for the stay. You need to have medical insurance, usually around up to 30,000 euros. And your stay can't exceed 90 days in a 180 days in the Schengen territory. Going back to what Tony said, he called it a back pocket letter. It's a great term to use. I think it's really important for any UK national coming into France or any other EU country, even if they are coming in under these means, to have that back pocket letter for them to be able to say, I am actually a business visitor. This is all the information that I should have as a precaution, and have that with them as they arrive in country. So this is an important slide to justify a bit more on that side. But if we may move into the next slide, if that's okay, Tony. So this slide just details what the short stay entry requirements are. So for example, additional control and entry restrictions when traveling to the Schengen area, that UK nationals are no longer now able to use the designated lanes at border crossing points. They will be subject to stamping upon entry and exit from the Schengen area. They will be subject to checks against databases upon entry and exit. And UK travellers are subject to the COVID-19 travel ban, although obviously this is very much fluctuating and can depend on the situation at the time. But it's really important to note that due to terror attacks and immigrant refugee crisis that took place over the last decade, the Schengen area has invested on mechanisms to increase control and security. And so at the start of next year, at the start of 2022, a new exit and entry system will be implemented through e-gates to eradicate the current system of passport stamping when travelling to the Schengen area. This new entry and exit system will facilitate enforcement of the 90 days in a 180-day rule, and all entries and exits of non-EU nationals will be registered through e-gates. This electronic travel authorization system is called ETIAS, and it might sound familiar to some of you who have traveled to the US or Canada, as it's a very similar system that's in place for the ESTA or the ETA for Canada. So as I mentioned, this is going to be implemented in 2022, and it means that there'll be an online authorization registration that would need to be obtained before traveling to the Schengen area. So you need to apply it before coming into any of those Schengen countries. If we could move on to the next slide, it's okay. So just to go into this slide in a bit more detail, this is I suppose what we call the landscape for UK nationals who go in for short-term business, and it is, as you can see, pretty complex and nuanced. It's not black or white, and it means really looking quite deeply as to what's taking place. So the main challenges we now face really revolves around the uncertainty around the application of the TCA and how each EU country will interpret the trade agreement provisions. So short-term business permitted activities by the same individuals across the Schengen area may exceed the maximum permitted stay in the Schengen area, which is obviously 90 days, and taking residence in the EU is the only way to carry out these activities. So what we're really trying to say is that third point there that's highlighted, what you need to do, what your employees need to do, what your family need to do is really make sure that you take track and record your stays in the Schengen area to make sure you know how many days you've actually physically spent in the Schengen countries, France obviously being one of them. It's also important, to complicate things further, we need to think about COVID. So the potential travel restrictions due to COVID-19 also need to be taken into consideration, particularly with the rising infection levels that we see at the moment. So that's something that we really need to be mindful of. Further to that, the European Labour Authority is working on an increase of working inspections of cross-border situations. So it's really important to be aware of that bugbear that I'm sure some of you had, which is obviously the posted worker notification, the posted worker rules. And to add to that, bearing in mind, obviously, the social security obligations on top of the immigration regulations that we're talking about today. So if we move on to the next slide, we've obviously discussed the permitted business activities, we've discussed the TCA, but what's really important for business to remain compliant is to understand work and residence procedure in the EU countries. And this is one of the elements over the years that I've been asked about and that we've always had to make clear. But as I previously explained, each EU country has its own national immigration rules and work and residence permit categories. Most long-term assignments and local higher immigration routes consist of 3 steps. The first is obtaining that work and residence authorization. The second is the residence visa and the Schengen visa application. Although visa-free in some EU countries for certain nationalities. The third is obtaining that residence card. So this is the case for a number of countries, whether it's France or Spain or Italy. You usually have to go through those 3 key steps. Post-arrival processes may also be available in some EU countries. I know that's, for example, the case in a number of countries, Italy being one of them, but it's currently not possible, obviously, due to the COVID-19 travel restrictions. Post-arrival processes may also be available in some countries, I said, but that's not currently possible. Now, there is not always a distinction between immigration processes for short and long-term stays. For those going for short-term activities under 90 days, it still might require a work permit. So you still might have to require that first step and that second step of the process. We're a little pressed for time, so I might skip over the next slide, which was just a brief outline of how that worked in another country. If we move on to how we adapt to the new immigration landscape, and let me just give you some information on what we think would be very useful. As we've gone through so much information, our advice in kind of a nutshell as to how you might want to adapt and what you might need to think about before we move on to questions. Tip 1, it's really simple. Well, it's not simple actually, but what we need to do is create more awareness of the changing immigration landscape. You have to know about immigration law in 27 different countries rather than just one. So there is no broad brush unique immigration policy at EU level. Tip 2 is to get familiar with the various work authorization procedures in each EU country, specifically with those 2 you can use for multi-jurisdictional work at EU level. So I would probably focus on the countries that are relevant to you, because it's likely it might not be all 27. It might be a handful, but it's more likely to be a few potentially that are relevant to you or your business or the business that you work for. So you want to consider different work permit categories. For example, the EU ICT permit for UK nationals employed in the UK on assignment to an EU entity within the same group of companies. Other options are the Vander Elts for the UK nationals employed and residing in the EU country, who require short-term services in other EU countries. Another one is potentially the EU Blue Card, who have mobility rights that are quite limited, but it can help with multi-jurisdictional work. A couple of final pointers before we move on to questions. It's worth adjusting your budgets and timeline to account for work authorization processes, as compliance is essential, not only at an immigration level, but at an employment law level in the EU as well. We do expect the posted worker notification to really be forced through in a more analytical and critical way by authorities. So it's really important that you be aware of that. The other thing that I would mention is to assess short-term activities and check periods of stay. So it might be worth using, for example, a Schengen calculator that you can access online, and you can maybe use the European Commission's version of that, which you might already be familiar with, as or Newland Chase, of course, can help with that on our side as well. But however you do that, And we, sorry, just to add to that, we have a tool called IMI-Smart that can help track that Schengen days as well. But however you do it, what's really important is to really be mindful of the 90 days within 180-day period to stay within the Schengen area rules. So that's generally the tips that we have. I suppose the final thing I'd like to say is you might want to consider moving your EU national to have in your workplace into a position that requires continuous trips and frequent business travel to the EU, which might help in a situation where you don't have time to secure work permits for your UK nationals, so that they remain compliant with immigration rules. So that's a very kind of quick summary of what the situation is generally. Now I think I'll pass it back to Tony, who I'm sure has some really great questions that you thought of since we've been speaking.
Great, thanks, Ben. We actually do. We have lots of questions. So I'll take the UK ones, give you a chance to have a look at the EU, and I think that will take us nicely to the top of the hour. So I'll read out the questions and I'll answer those as we go through. So one question, and this is a great question, relates to right to work checks. So as part of the employer pre-work checks, will we now have to ask for a copy of pre-settled status on top of the valid ID? It's a very good question. So the position as it currently stands is that we're in a grace period, and the grace period runs up until the 30th of June. During this period, the Home Office have restated their position very recently that companies do not need to check whether or not an EU national has pre or settled status. They can still rely on the passport or the national ID card to establish a statutory excuse against a civil penalty. So as far as your right to work checks go throughout this period, you don't need to do anything any different than you were previously. Okay, that is expected to change on the 1st of July, and the Home Office will publish updated right to work guidance. One thing I would say though is that a lot of our clients are taking steps to actually encourage their EU nationals to provide them with evidence that they've acquired pre-settled or settled status. One thing the Home Office is keen to impress upon organisations is that they cannot insist on it. It does bring into question things like discrimination. So you need to be a little cautious about how you go about requesting that type of information. As I say, most of our clients are taking a fairly soft approach to this, encouraging them to do so, asking them once they've acquired it if they don't mind to upload that information. So that's the position right now. And as I say, we are expecting updated right to work guidance before the end of June. Let's have a look. Sorry, I should have been a little more prepared for this. So another question has come through, a couple of questions about the same topic, which is interns, and we've been asked about this a lot. I mentioned in my presentation that interns can't come to the UK under a business visit, but there are visas in place. Typically, the visa scheme in place to allow companies to employ interns would be the Tier 5 government authorised exchange scheme. There are a list of organisations which are part of the Tier 5 GAE. Depending on the sector you're in, looking at the scheme itself, interns can usually come to the UK for up to 12 months to undertake an internship. So you would need to look at the sector you're in, look at the available schemes. As an organisation, you would typically need to register. The types of organisations that can issue a Tier 5 certificate of sponsorship are listed, so that's available to check online. The one that we partner with is a company called GTI Solutions. They're pretty commercial. They issue certificates of sponsorship for up to 12 months. One thing to mention, you do not need to hold a skilled worker sponsor license. It's helpful if you do, because it means you have good compliance processes in place, but it's not a prerequisite. But as I say, interns typically will fall under the Tier 5 scheme. Another question is the sponsor license. How long is it valid for and the costs? So it's valid for 4 years at a time, and you can continue to renew that in every 4-year cycle. Let's have a look, see what else there is. French visitor working in France under a French contract needs work visa to be able to come to the UK 2 to 3 days a week. Yeah, that's right. So that sounds like the cross-border commuter, somebody who's living in France, working in the UK, travelling back and forth, may benefit from the frontier worker visa. I would recommend you look to see if they qualify for that. That's certainly one that's worth applying for. Can the subsidiary based in the UK send? Okay, sorry, I see these are skipping. Do you have any advice for dual nationals when travelling between the EU and UK? How would this work with passports being stamped? Well, if they have a European as well as a UK British passport, then of course when they're travelling to the UK they would present their UK passport, and when they're travelling to the EU they would present their European passport. And we see that all the time with dual citizens. They simply use the passport of the country they're travelling to facilitate their entry to that country. Ben, do you want to pick up on a few? Sorry.
Yeah, I do. Yeah, that would be great. I'm going to amalgamate some of the questions because the answer might be pretty much around the same umbrella. Laurence Parry, can a subsidiary based in the UK send their staff for training on a product in France? Great question. And we were asked a similar question in terms of what activities you can do. Laurence, that's a great question, and it's one of those questions where I would probably say that we would need more information from you. So in terms of the permitted activities in France, there is some information available on that. It's not as comprehensive as what you can do in the UK. Training is one of the permitted activities under the exemptions and permitted activities as a business visitor, but it very much depends on whether the training is being given or received. It also depends on whether the training is something that is, I suppose, billable. I mean, that's the key element here. Whether the client is actually paying for that training is another element. So my answer to that question broadly is we would need more information. Training is something that could potentially be permitted as an allowable activity, but we would need more information to see what specifically is going on there. The other thing that I would say that might be relevant, that's again, if we had more time for this webinar, is that certain countries have work permit exemptions, and this is key potentially France. So under those exemptions, you can do certain things, for example, sports activities or modeling or filming for up to 90 days, 180 days. Another key one I feel that perhaps from our audience here is the exemptions available for employees on detachment doing audits or IT or management finance related roles, and they might be permitted under work permit exemptions in France, but that is something that we would need to really take a deep dive and assess in more detail should you have those specific questions on that. And one final point that we were asked about was whether do we count holidays and work days in the 90 to 180 days of travel? It was an anonymous attendee, whoever it was, fantastic question. The answer is absolutely yes. Yes. So if you have employees in your company that have I don't know, a nice holiday home in France, somewhere in south of France, and they're going there or want to go there after or when we all can, but they're also going on business meetings, we absolutely need to pin them down and ask them how long they're going for, and actually have that mapped out in a spreadsheet. They need to be able to track that, or you need to be able to track that on their behalf. But whoever it is something that is counted as those 90 days. And obviously it's not just France, we need to look more broadly at the Schengen area, whether it's Italy or somewhere else. So do be mindful of that. But I know we're reaching the hour, so that's probably all on my side that we have time for. Tony, was there anything else you wanted to answer, or should we pass it on to L'Oreal?
Yeah, I've got a couple more, which I think are really good questions, and I'd like to answer. So another question is, how can international businesses bring in lower paid employees for roles that might not be classed as skilled, such as office, customer service admin, and so sales type roles. These businesses need language skills not provided by UK workers. So unfortunately, the Home Office have not implemented a scheme for much lower skilled workers. As I mentioned in my presentation, the minimum skill threshold is set at RQF level 3, which is broadly the equivalent to a UK A-level education standard. So if they meet that criteria, then they would qualify for a skilled worker sponsorship. Unfortunately, if they fall below that and they don't have an alternative visa to come to the UK, for example, a frontier worker visa, frontier worker doesn't have a minimum skill threshold, do bear that in mind. Or if they're not married to, say, a British citizen, so they may qualify as a spouse, then unfortunately they wouldn't qualify. So again, we'd need to look at the role itself, we'd need to look at the salary that you're paying, but if it fell below RQF level 3 and the minimum salary requirement wasn't met, then they probably wouldn't qualify for a visa to come and work in the UK. And there was one other. So for a skilled worker, quite a simple one, for a skilled worker under the EU settlement scheme, pre-settled status, there's no need to apply for a skilled worker visa, that's correct, but how long would it last? So pre-settled status, so the intention of the settlement scheme is for all EU nationals to acquire settled status. They acquire that after 5 years. So once they've accrued 5 years of residence in the UK, then they should be eligible. There is a criteria around absences and meeting a residence requirement, but assuming they meet that criteria, then they should be eligible to convert their pre-settled status to settled status, which is essentially permanent residency. Once they've made that application, they have permanent residency. They've done everything they need to do to shore up their status in the UK. And a final one, because it's a quickie, the position of EU nationals who are board directors of UK entities visiting the UK for board meetings, perfectly fine, can come here as a business visitor. Again, would recommend the letter just to confirm why they're coming, the duration, but that would be covered by the business visitor rules. There are lots of other questions. I think we've run out of time, but what we will do is we'll look at the questions and we'll provide a response to the French Chamber to distribute to those who have made the inquiry. So we do aim to do that, I think, within 48 hours. So if your question hasn't been answered live, look out for a response, and do feel free to reach out to Ben or I offline. We'd be very happy to pick up your queries after the webinar. And I'll now hand you back. Thank you.
Thank you very much. I will be very quick because we're slightly over time. But I just wanted to say a big thank you again to Newland Chase and CIBT for this webinar this morning. Thank you to Tony and Ben, our speakers, for this great presentation and the impressive number of questions you covered in just 15 minutes. And thank you to Joe for your help setting this up. As Tony said, we'll keep track of all the questions that have not been answered at the moment, and we'll be sending the responses hopefully before Easter break. So thank you all very much for joining us this morning. We hope you found the webinar helpful. And with this, I will leave you to enjoy the rest of your day. Thank you.
Thank you.